I think the most important thing about life is, as much as we go to work and everything, you always want to be, at the end of the day, when you are done with work and you're just chilling at home, you want to say, at least I did something good for. Sometimes you feel like people, sometimes they don't know why they go to work. If I were in that position, I would really have a discussion with an employee for us to part ways amicably. You literally, and you have to, you can't, you can't wing it. That's key. That's another thing that we wanted to say. People are not prepared. That's why they lose. The case that we have seen, when the ones that we have seen that there are good prospects of success.
Yes.
It's not to say the employee was not misbehaving. They were starting to misbehave, but we felt like, there was a rushing of terminating the employment space before the maturity of the offenses. Coming from Wits, did my LLB. Yes, I did my LLB at Wits. Yeah, you have Wits as well.
Wits as well, bro.
Yes.
Cool, right?
We're always on the edge, right?
On the edge, my brother.
Yes. So yeah, I think it has been a journey. It's one of the consulting space has been something that I really, really am passionate about, and we get to. I think one thing with labor law and employment law is we're in the business of people.
In the business of people.
We deal with people to happen, in the employment space. I would want the same character, attitude that one has when they are going for interviews on their first day to be the default attitude, during their employment journey. Because in the first day, everyone is on their best behavior.
Hey family, welcome back to another session of Sisol Workforce Talk. I'm your host, Solomon Makobako, and I'm here today with a guru in the labor specialist, with a man that goes to CCMA representing employees and also helping employers. I'm here with Tatenda, a director and a head of employment relations / dispute resolution at Employment Law Veritas, right here. And he's here to talk to you today about the mistakes that employers make and also employees make when it comes to the CCMA, disciplinary hearings. And I think this is the most important thing that we need to talk about, because every day somebody gets dismissed, somebody sits in the CCMA, and sometimes people don't even know where to start. So for us to give you advice, to give you valuable insights into what Tatenda does and how he helps job seekers, employers, and employees. Those are our audience. Tatenda, my brother, thank you very much for joining us today.
Thank you, Solomon, for having me.
I can't wait. I can't wait to talk about, to hear about your journey, your plans, your future, and a bit about your past as well. And also what you do. But I can sit here and read about it. But you are here to talk to the viewers about it. Tell us about yourself, Tatenda. Who's Tatenda?
Yes, thank you, Solomon, once again for having me, and thank you so much, and hello to your listeners, to everyone who's watching. So I'm Tatenda Makoni. I'm based in Fourways, Johannesburg, at labor law consulting called Employment Law Veritas. So I do dispute resolution there, and also assist in strategy in terms of litigation. So I think we've been operating for, over 10 years now in the space.
Congratulations.
And it's been a journey, dealing with assisting employees primarily, and also, helping employers in terms of, making sure that they are compliant in terms of the things that they need to
Yeah.
do as they are guided by the law. So it's been a journey, coming from Wits, did my
You went to
LLB.
Wits?
Yes, I did my LLB at Wits. Yeah, Wits as well.
Oh, Wits as well, bro.
Yes.
Kudu, eh?
We're always on the edge, right?
The edge, my brother.
Yes, so yeah, I think it has been a journey. It's one of the consulting space has been something that I really, really am passionate about, and we get to. I think one thing with labor law and employment law is we're in the business of people.
In the business of people.
We deal with people, and you get to meet people at their wits' end sometimes, and we get to have that opportunity of trying to fix, and make that environment a better place. Yeah.
Interesting.
Yeah.
So, well, vetting myself as well.
Yeah.
I remember when I was still studying,
Yeah.
I met a guy who's my mentor
Yeah.
by the name of Clifford Chowke. I don't know if you might have heard.
I've heard about Clifford, yeah.
He used to be the employee relations specialist for vets, from junior to senior, and then promoted and left.
Yeah.
I didn't know about labor law, to tell you the truth.
So you didn't do clinic
No,
yet?
I
You
didn't.
Oh,
I
okay.
didn't do law. I actually did labor relations.
Oh, is it?
Industrial sociology.
Wow.
And then also psychology. Then I went later to do employment law with University of Johannesburg.
Okay.
So, how did you get to fall in love with the people, with this space of labor?
I think it's crazy because of all the electives, I think labor law was one of those electives that I just, it was one of the last picks where I was like, no, there's no money, because I think in the WITS environment, the commercial space, if you're going to take your electives, they have to be the commercial, your taxes, your something that gives you value, your intellectual property, that those heavy corporate where you'll be working for the big five. So I just decided to say, I don't have anything to do. Let me just put, labor law. And then when they, in law clinic, practical legal studies, they assign to you a specific unit that you get to, work in. And lo and behold, they gave me labor. So we're in the labor unit, me and my partner. And that's the space where you actually get to see that you're dealing with, sometimes when you just study law theoretically and you just don't get to the ground and you meet people, you actually see that, no, these are real life issues. These are not just cases. Sometimes you just read cases from a case journal, but when you actually meet to say, okay, this is Solomon. Solomon was working here and he has come with, the kids, things that have been affected, they were unfairly treated. So I think it brings home to say, these are real lives. So from there, still, I wasn't really convinced at that time. I was like, okay, let me just do it. Let me just do it and pass. But I think when I finished school and then I was now looking for a job, and the first job that I got was a firm in Rivonia, and they were specifically dealing with labor law matters. I think that's when I started actually understanding the labor law space. And that's when I actually, when you see people, you're helping people, I think that's when the passion was ignited in me even more, in that space.
That's crazy, Tatenda.
Yeah.
I mean, that's insane,
Yeah.
I mean, from being a student to helping people before even graduating. I mean, for me, I always loved working with people. I think that's the reason why I find myself where I am.
Yeah.
But as an entrepreneur as well, on the other side, the passion that I have for business, the passion that I have for job creation. In Africa there is, small businesses, they create a lot of employment. And mostly small businesses don't even know how to navigate this labor dynamics. So with that, what inspired you to wake up in the morning and say, you know what, corporate, bye-bye. I'm going to start a consulting company.
I think so. We at Employment Law Veritas, it was me and my colleague. I think that when we were working, we were fortunate enough that we were working at the same, firm together. So we got to work together.
Is this the guy that you were doing law clinic with?
No, it's a different guy. But he's also a VT. My business partner is also a VT. But we also knew each other in the school circles. And and he was ahead of me. So when I was now looking for a job, he was already a manager at this firm. And he was like, no, dude, why don't you come? So when we came, we just became like brothers, and it's like, you know what, after this, what's next after this? And we said, you know what, let's think about starting something, along those lines. So he actually went and he started, a Veritas. We thought about it. So you're gonna start, you're gonna leave, you're gonna resign first.
Yeah.
And like last in, first out. That type of environment. So you start in, and then and then I'll come. And then he started, and then I joined him. But it was always been a passion for people, because we are people-centric. We love people. And I think the most important thing about life is, as much as we go to work and everything, you always want to be, at the end of the day, when you are done with work and you're just chilling at home, you want to say, at least I did something good for nature today, for community today, for the world today. I've left the world in a better space than I found it. And I've seen various disciplines of law. I stand to be corrected, but
yes.
labor law is one of those spaces where you really have an opportunity to change people's lives, families, because labor it's because that's their heart, that's their brick and mortar, that's their bread. They are working. That's where they get their livelihood. And we get the privilege and an opportunity to be, sort of a blessing in that space by assisting people, whether it's from the employer side, the employee side, because these things, they affect your daily living. And you see, majority, if you look at majority of people who have depression, who have stress, ask doctors, most of them, they are work related. So it shows you how significant the employment industry is. And that's why, I found passion. And it was easy. It didn't have a lot of, drama. I didn't have to be dealing with a lot of bail applications here and there, back and forth. I was just dealing with, fixing what needs to be fixed in that space. Yeah.
How I know that you represent most employees, like you said in the introduction. How does it feel to have someone who was unfairly dismissed?
Yeah.
And then you go to CCMA, they win that case, then they get reinstated. How does that make you feel at the end of the day?
No, I think you feel that justice has been served, because I think I know you are in the other side of the ledger,
Yes.
But the reality of it, Solomon, is in South Africa, in our context, the bargaining power is not the same.
No, it's not.
The bargaining power is not the same, and you find that the employees, they always have, I believe they always get the shorter end of the stick. And obviously, we give kudos to our Constitution and the Labor Relations Act and the various legislations that encompass around that, because they try and bring some form of, equality in that space. But when an employee has been reinstated, there is this sense of fulfillment that comes, where you feel it's like a doctor who has done in a successful operation, and they've seen that they're able to replace a kidney. You know that this person is going to face tomorrow in a better space, and they will be in a better position to live and fight life again. So it's very important. Like today, we just received an award, and this employee legal representation was denied. So we had to take time to coach the employee, literally, create everything, from how opening statement, everything, cross-examination. We literally had to prepare everything for them. And man, we would call us crying. I don't know what to do. I feel like the commissioner is a lot. What do I do? You're receiving those texts and you have to respond, because the attorney who had been assigned had been denied legal representation. So you have to assist. And that feeling, I felt it this morning as I was coming to shoot this podcast, because we got the award, and she managed to get maximum compensation of 12 months salary.
You're kidding me? 12 months?
She got 12 months. And I think that feeling, Yeah, that shows that you've done something amazing to
Beautiful.
someone's life. Yeah.
It's my heart is melting. Even though that I am on the other side
I
of
know.
the coin,
Yeah.
I can tell you one thing. I always live by, the value of fairness.
Yeah.
I believe that even my clients, if you want to fire somebody and you don't have enough evidence
Yeah.
or ground to really say you want to dismiss this person, I'd always tell them that you can't.
Yeah.
If you're going to do it, sharp, do it, but it's going to cost you money. So you just need to know that. I mean, saving somebody's job on its own, in an unfair dismissal.
Yeah.
It's really serious justice. It doesn't only affect, dismissal doesn't only affect the person that was found guilty and dismissed, or just told that you are fired, like American style.
Yeah. Yeah.
I think you are really in a position where you do like, I'd call it the Lord's work.
Yeah.
I believe.
Definitely.
I'm a very faithful person.
Yeah.
And that is amazing. So tell me, what type of cases do you mostly handle?
Yeah. I think they're your normal bread and butter, your unfair dismissals due to misconduct. People do misbehave, I must say. I don't know why. I'm always thinking, when sometimes when you read the charges,
yeah,
you'd be like, what causes, one to misbehave? Sometimes you feel like people sometimes they don't know why they go to work, but it's usually misconduct. I think I can say 80% of the matters are misconduct matters, where you can really see that people are misbehaving. You deal with your constructive dismissal matters, your dismissal due to, poor work performance, and then your probations and your retrenchment. Seldomly now we deal with a lot of retrenchment, but I say majority will be your unfair dismissal matters.
Wow.
Yeah.
Same on
the other side, right?
Because most of the times it's always about somebody who breached the rule, somebody who was absent, somebody who came to work under the influence of alcohol, and all those kind of things. But how do we, from your side? Yeah. Because my mindset is the employer side. 97.999%.
Definitely, yeah.
So from your side, how do employers, prepare themselves and ensure that such kind of dismissals, like having to pay 12 months. I mean, that's crazy. I mean, if your business is a small business, then you know that person might not even be able to pay that money. Yeah. Right. So, what would be your advice to employers when dealing with disciplinary issues?
Yeah. I think one thing that I've noticed, Solomon, thank you for asking that question. One thing I've noticed, the employment space, if you're going to do it, you're going to do well as a employer, as an employee. I always tell people, do not enter with heart. In the sense that don't take things personal.
I love that.
Don't play the person, play the game. Because many a times, if you're an employer, let's say you have identified an employee who you feel like this employee is a misbehaving employee. I don't think, because many a times, because you are dealing, for example, I'm just taking an example of a line manager. We have seen an employee who's insubordinate, who's insolent. So what tends to happen there is a high level of emotions that, that are evoked. So there's a lot of provocation in that environment where they are late and they don't really recognize you, as an employer or as a leader. So you will find many a times people would then, use their emotions to bypass the processes and the policies that are enshrined in terms of the law. Because the law does say, show the progressive warning system. Go through, be thorough. Don't be petty. But sometimes, people then take it personal. Yes, it is personal, but the system or the process that the law allows, it's not personal. You just have to follow it, And I think sometimes, many a times, people they put the cart before the horse. They're just gonna say you did this wrong, and then we are letting you go. Or they'll just find something that is not as gross as it should be.
I love the fact that you're talking about the grossness
Yes,
of the offense.
the grossness of the offense. Because someone who can just say you were late, it's gross misconduct, and then because they want to get rid of you, they've already made up their mind.
You think they've already made up their mind? Yeah,
Most likely. And then then now it becomes, because most of the cases that we have seen, when the ones that we have seen that there are good prospects of success.
yes.
It's not to say the employee was not misbehaving. They were starting to misbehave, but we felt like, there was a rushing of terminating the employment space before the maturity of the offenses.
But
because they have to be, at least they have to tip the scale to say definitely dismissal was the only thing to go. I think that's what I have seen as well.
And for me, on my side, I think I have a problem with what you are saying.
Yeah.
My problem is, at what stage would you be satisfied if an employee comes to you and say, you know what, I've been dismissed, and this happened, and this happened, and this happened.
Uh-huh.
At what stage would you be satisfied that the scale has been tipped, that right now the case is ripe and the employer did everything right?
I think we look, obviously you look at the various things. You look at the service record. You look at the offense itself. Because it doesn't, and you also are guided by their policy to say, if they say, if you break a glass, we give you a warning. And then sometimes you find, they didn't break a glass.
Yes.
But they were given a warning. So now you have to now look to say, did the employee, did they have a bona fide defense? Because sometimes someone will say, I was late because there was just an accident and I took a photo. I sent my line manager. I showed them the traffic. It was beyond.
But the employee was late.
But the employee was late.
Yes.
We're not saying that. But now you have to now look to say, could it be something that the employee was intentional about? Was it in good faith or it was in bad faith? So you look at various aspects as well. But what you're saying, I believe majority of cases where you see an employer trying to dismiss someone, I don't think they just wake up and they say they want to dismiss someone. I don't believe so. No. I don't believe so.
Yeah.
I know our people sometimes, majority, and let me not say sometimes, most of the times they're misbehaving. But the only challenge sometimes is maybe what should have been a final written warning or a written warning might be escalated into something that is dismissible. That's what I'm saying. Maybe it's not yet ripe. That's way. But in answering you, from an employer side, let me put also points from you. Sometimes I understand that if you have an employee who is a bad apple, because I'm also an employer, I also employ people, and one bad apple can affect 10 good apples.
I'm glad that you're also an employer.
Yeah. So so I understand as well when the employer are like, no, man, we are not going to wait for that ripening and maturity that you're talking about, because this person is starting to sow discord amongst the employees.
I want to pause you there. So sorry for disturbing this beautiful podcast. I thought this would be important for you to know and to learn. At Sisol Holdings, we help a lot of employers with labor relation matters, from investigation to disciplinary actions, chairperson to building company culture and through company policies and procedures. So if you are currently looking to update your company policies, if you have a disciplinary case that is pending and you're looking for investigators or a chairperson, Sisol Labor Project is always here, and it will make sure that you are represented also in the CCMA through the Bargaining Council. So apologies for disturbing. Let's continue with the podcast. And actually, I want to talk about that part.
Okay.
So as an employer, and you realize that there is this employee instigator.
Yeah.
Because sometimes employees they come from their own environment.
Yeah.
And they join your environment. You have your rules, your policies, your values.
Yeah.
But they break everything.
Yeah.
And sometimes you can't wait.
Yeah.
I just want to put it out there. Sometimes as an employer, you cannot wait for an employee to give them written final
Yeah.
up until the last stage.
Yeah.
Sometimes if you wait, you might lose your business.
Yeah.
You might lose a client.
Yeah.
In that case,
Yeah.
from your perspective as both the employer and also representing employees,
Yeah.
what would be your best advice in dealing with those kind of matters?
I think my advice would be, I think we should never allow things to escalate. And I think it's one of the things that, since you obviously in that space to provide employers with a lot of training to be able to identify the bad apples timelessly. I think that's very important.
Love that. Yeah.
Number two, once you see a bad apple, and because most of the times it's attitude, I don't think there's no amount of warning that can change a bad attitude into a good attitude.
There is no amount of discipline that can change somebody's attitude. I love that.
Yeah.
Yeah.
The best thing an employer can do is definitely, if I were in that position, I would really have a discussion with an employee for us to part ways amicably. Yeah, that separation, the law does apply for that. Because the most important thing now is an employee who's disgruntled. Disgruntled employees create other disgruntled employees. And it's easy for them to affect people who were okay. That's true. That's the challenge, and that affects productivity, and then that affects other people who have nothing to do with what's happening. Because everyone is, imagine in a canteen, everyone is not happy, is grumbling, and no one is willing to be willing to listen. So it becomes a sticky situation. I would think I would have that, and you'd literally say to the managers, the line managers, to literally address those concerns timelessly. Yeah.
This would be like a bit of your opportunity cost kind of thing.
Yes, exactly.
Yeah.
Definitely. Because you're going to look at to say, if we contain this person for long, we might start with one disgruntled, but by the time we are done, we might have a lot. The team is affected.
So in case, let's say you then call an employee in, and then you say, look, you've done 1, 2, 3, 4, 5. You know what? I think we should separate mutually. I'm going to give you this. And the employee says, no, I don't want all of that. I just want to work for you and continue, messing up your business in a way.
Yeah. So I think the provisions of the law, because that would be the gratuitous way of doing it in terms of approaching an employee and say, look, I feel like you're not we're not compatible. So if you give them that olive branch and they refuse, then you do the incapacity for incompatibility, where you say, because the law does allow you to do that, to speak about that, to say you're causing disharmony, you're causing the workplace to be a disharmonious environment. So now we are looking at the incapacity route, where you can literally separate with an employee because there's no compatibility. Because incompatibility, it is a ground for separation.
I love that
in that space.
Sometimes I meet employers who don't know what to do.
Yeah.
They don't want to part ways with money because the person wants maximum 12 months, 24 months.
The moment they feel like it's an open check for me to be rich.
Exactly. Yeah. For them to go on holidays and do whatever.
Yeah.
But anyways, why do you think employers lose cases? They believe that they are straightforward. Sometimes you have this case and this person was absent for 70 days in a year, and then you go and dismiss, but they still go to the CCMA and lose cases. What do you think is most of the time is the cause of that?
Yeah, you're putting me in a very sticky situation. I still want to go to the CCMA. But I mean, there are various reasons. It just depends. Have they followed due process? If they haven't, most likely the CCMA is going to hammer you on that. And yeah, I think, officially, I think that should be the only reason where employer is not done. And sometimes, the thing is with labor law, Solomon, you would know that it's a very specialized industry.
Very, very specialized.
It doesn't mean that if you've got an LLB or you're an attorney, you automatically know the ins and outs.
Very,
You know, so sometimes someone unpreparedness can make someone who's not clued up, unpreparedness of the practitioner who's representing an employer can literally affect the place. So it's important for you to really know, because I've seen people sometimes, there are matters where cases where I'm speaking to the other side, like I do dispute resolution before going to the CCMA. And then I'm speaking to a legal representative on the other side, and I'm telling them, this is an open and shut. Let's settle.
Yes.
But for some reason, someone actually thinks, no, they actually have a strong case.
You see,
so you wonder, like, which rule book are we reading? Are we reading from the same book? Okay, did you even put it on Google? Just ask ChatGPT.
Yeah, at least.
At least, I even had to tell other employers, you know what, just take the facts, put them on AI, and come back to me, let's discuss. But people just still, I don't know how sometimes we just have different opinions. That's why, you always in court have majority and dissenting judgment, I guess,
No, that's for sure. I mean, that's the nature of the business.
Yeah.
There isn't, the way the legislation was drafted, mostly Labor Relations Act, it's not it's very straightforward to say that if you do this, then this happens. This is how you interpret it. As to how you view it and the other party views it, I think it's a little bit, could differ in most of the times. But let's talk about this one. Can a guilty employee, let's say I'm the employee, I go to a hearing, I plead guilty, and then we go to CCMA, then I get there, and then I win the case. After pleading guilty, I'm actually stating this because there's a case that we did. CCMA case. We received the award last week.
Did you guys win?
Yeah, no, we don't lose, Chief. We don't lose. So what transpired is the employee pleaded guilty in the hearing. Then went to the CCMA, opened a case of unfair dismissal. This employee was represented by an attorney. We were representing the employer from the employer's organization part. So this employee then, when the commissioner asked if she concedes to the allegations, she said no before the commissioner. But the outcomes of the hearing says she essentially pleaded guilty, and the recording reflects that. Now, when you have this kind of cases, I know sometimes employers will have this kind of cases. They get to CCMA and lose the case. So is it possible that you have solid case, like you said, you have your facts right, you have your evidence, and still lose the case?
And it's a gross offense.
People still lose those cases, and I don't know why.
It's very concerning. I get what you're saying. It is concerning that sometimes you see, I always tell clients to say, I've seen a good case lose and a bad case win. And like what you're saying, from what you're saying, if the offense is of a gross and of a grievous nature, I don't think the judgment that was made there would be the correct one. And I think that's why the provision of our law allows us to actually take a matter on review to the labor court. Because I think it has that allowance to say, people the commissioner might not apply their minds correctly in that space. So at least to the employers, it is some form of consolation. I think on both ends, both employees and employers, that at least there is the process of the labor court, at least that allows for you to go through that end.
Very expensive process, though.
Tedious, time consuming. That's the unfortunate part. And I believe I think we should if our legislators can work on just trying to make that process not as expensive and tedious for our people, because you can just imagine someone who's an employer now, they have to spend so much. Same with the employee who might not even be working in that space.
At that time, the person is not working, and then boom, you lose the case. it's grossly, the commissioner probably, grossly conducted themselves.
Exactly.
And for you to take that case to the labor court as an employee who's unemployed, who doesn't have insurance, who doesn't have you,
becomes a problem.
Yeah. But do you normally come across those kind of cases where a person comes to you and they can't afford to take the case to the labor court?
Yeah. We do.
Yeah.
We do. We actually assist.
Okay, please.
But it depends if, obviously, your merits, because I think we go to the labor court now, there's an issue of costs. Definitely. In terms of if you lose the matter, the other party can apply for costs. So now it has to be on merit. It has to be, but we do assist. We do a couple of matters that we're actually at the labor court and the labor appeals court right now, that we are actually working in that environment. Yeah.
Okay, so what kind of evidence would you say? People come with. I've seen some cases that I took from someone else.
Yeah.
Now I have to assist.
You have to continue.
And you realize that the evidence that is in the bundle, it's actually not evidence.
Yeah.
It's not strong enough.
Yeah.
You see things like affidavits.
Yeah.
Statements.
Yeah.
But the people don't exist.
You see.
So what kind of evidence would you say it weighs more and better for either employer or employees when they refer their matters to CCMA?
Yeah.
Because sometimes you'd hear people coming and say, but the company did not, this person did 1, 2, 3 and they were not dismissed.
Yeah.
So there is no consistency. Those kind of things. And they happen every single day.
Yeah.
That she was late, but I'm the only one who got dismissed. Or, whatever, we're working together and I'm the only, when this happened and I'm the only one who got dismissed. So what kind of evidence would you say would be best kind of evidence to present before the CCMA instead of using your heart and emotions?
Have you been watching the Matlanga Commission?
I've been.
I think everybody, but I think the best evidence, the reason I'm asking is, the best one is a human being. I think for me, in terms of evidence, having a witness is always something that it's a stronger corroborative, piece of evidence that you can use. Having someone there. If you can't, because sometimes, an affidavit, it's not really going to help you because the other side can always, disprove or challenge the authenticity of the affidavit because you can't cross-examine an affidavit. Yeah. You see? So you'd rather have a person. You'd rather have documents, official documents. You'd rather have WhatsApp conversations. You'd rather have emails. At least those are admissible. That type of evidence to show. And it must be relevant. Because I think with evidence, it's not just having, because I know clients who say, I have documents. And when you check the documents, you look at, they are not relevant.
And it's a huge bundle, eh?
How does that work in line with your case? How does it prove that what happened to you was unfair? If you are saying there was no consistency, what evidence do you have? Do you have evidence of that specific person's disciplinary file? Do you have the offense? So there are specific things that are in line to your matter. Because sometimes a bundle can be a full bundle of nothing. Where you can't even use this stuff. You keep on flipping the pages. Yeah. But I think it has to be relevant. Case in point, when you look at Matlanga, you know that each and every page that those people are going to bring you, it's going to be relevant. Because they're going to be asking you about, and it's something that you should be able to show. Because I think that's what the commissioner is looking for. Because they don't know exactly what happened. But the evidence that is gathered there is able to convince the commissioner on a balance of probabilities. Yeah.
Speaking of Matlanga Commission,
I don't know why
I've seen a lot of people biting their tongues.
Yeah. No, it's hectic.
How important it is to prepare your witnesses before you can actually say, I have witnesses?
I think the whole trial is one in preparation. Everything is one in preparation. Success is when preparation meets opportunity. So that becomes very key. So it's key for the witness to be prepared. They have to know. we have to, it's role play. We literally have to know what we are going to say, how we are going to say, how to anticipate. Like
Everything.
everything. For a case in point, in this matter I was telling that we want 12 months, I literally we had to prepare 14 pages of to say, if the employer says this, this is what you're going to say. This is what you're going to say.
14 pages.
Yes, we had to prepare 14 pages for that thing, and to say, this is what you're going to say, and you literally, and you have to, you can't, you can't wing it. That's key. That's another thing that we wanted to say. People are not prepared. That's sometimes that's why they lose, and people are not honest. You can't just say deny, deny, deny.
Yeah.
There are certain things that you have to say, this I have no evidence. Let me admit.
Yes.
But at least it then shows you as a credible witness. Because once you can deny things that are so clear, then, even the person who's hearing your story won't believe even the things that are true that you're going to be saying. Because you have muddied the waters with your testimony. Yeah.
That's normally how I love my cases.
I can imagine.
I normally win my cases in cross-examination.
In cross, yeah.
that's one part of labor law that I enjoy. Revealing the truth.
Because you're gonna catch them.
Because you're gonna catch somebody, right? Because you come with the story and then you present the other thing. So, what rights do employees often misunderstand? Can we talk about this?
Yeah.
And it's not only employees.
Yeah.
Also, employers sometimes misunderstand.
Yeah.
Some of their rights in a disciplinary hearing.
Yeah.
In your experience, what have you seen so far? What have you come across?
I think one of the rights that I've seen is actually the right to be represented by a fellow employee. Because sometimes people are so afraid, because sometimes they come to us and say, can you represent us? Can I get an attorney? Can you guys get an attorney for me to represent, and be like, when we look at your notice, it says that, attorneys are not allowed. External legal representation is not allowed. But you are allowed to be represented by a fellow employee, a fellow shop steward, a union representative. So it's one of those rights. I think people must know that when they go through that, they are also, they are not alone. They can be represented.
Yeah.
And also the right to actually have the ability to record a meeting that you are in. So I think it's one of those, because people don't even know. Like, you then find out at a later stage, but in the hearing, they said, I'm not guilty. They scrapped these charges. And then when they see the outcome, when, the chairpersons have written the outcome, and the outcome says you were guilty, but like, why couldn't you record? So I think it's one of those rights, those fundamental rights, to actually say, you have the right to record a proceeding that you're party to.
So this is, I want us to talk to the many chairpersons out there.
Yeah.
The right to record.
Yeah.
Remember now we also have protection of personal information.
Yes.
What's the overlap?
Yeah. I think the law, I think Section 3 of the RICA Act does say, if you are a party to a proceeding, you're party to a conversation, you are allowed to record. Yes. But you can't then do clandestine operations of recording someone who doesn't even know without their consent. So consent must be given. But if you are in a hearing, if you're meeting with your manager, even if you were from an employer side, HR, line manager, you are meeting with an employee, you are addressing those concerns, you can literally record. And I think now with the technology of today, you go on Microsoft Teams, it enables people to record, so it's something that is now common. What is just unfair is to record someone without their consent, without you being party to that recording, where you just leave a recording there and then you just go away, like you're spying on people. Then now it's regarded as illegal. Yeah.
No, that's quite interesting to know.
Yeah.
I know that a lot of people don't understand this.
Yeah.
I've seen employees in cases, firstly would request, chairperson, can I record?
Yeah.
Firstly, but normally from my side and my understanding of the law is that as long as you are part and parcel of the conversation, then you have a right
You have a right.
to record.
And that right is very important because you get to actually remember for your ease of memory. For your ease of memory. And it's one of those things that the law does make provision for. Yeah.
There's one right
Yeah.
that I want to talk to.
Yeah.
The right to be heard.
The right to be heard, yes. Everyone wants this. Everyone wants this right.
Yes, it's your constitutional right. Above and beyond Schedule 8, it's your constitutional right.
Yeah.
You know, to speak your mind. As long as you take the responsibility.
That's the thing. You have to take responsibility.
Yeah.
And I think, yeah.
You know, please proceed.
Yeah. I think it's that right is very important. Because it's at the heart of our people, even from both ends, because that's why even how the labor relations came, you know, because our jurisprudence is in our constitution is rich in that sense that it gives you the Latin term odi partem, you know, principle.
Yes.
Where it says we must give both sides. Because back then in apartheid, we were not given the right. You just said, this is what the bosses said, that's it.
Yeah.
You know, so we come a long way. So even criminals in their worst state, they must be given the right to be heard. It's at the heart of fairness. And in the employment space, I think employers must understand that this right, there is no amount of misconduct that trumped the right to be heard. Doesn't matter, even if I shoot someone at work, it doesn't mean that that right, you know, not to be heard is infringed and impugned because I've done something that is so gross. So sometimes we'll be like, how can we do that? Because we have had cases where people fight, you know, they have a physical fight and they throw desks and gets hectic. And then the employer just says, I can't tolerate it. You're fired on the spot. You know, and when you try and tell the employer to say, that right has been infringed. That's the procedural part. So you still have to show that right so that we don't show precedent. Because you know the law comes with precedent.
No, of course.
You see. So we don't want to create a precedent for someone who who wanted to, you know, to be expressed, to give you context, and then we fire them. So that, I think it's very key.
I've actually seen employees, Tatenda, from different levels, right, from the top to the bottom, deciding that I'm not going to say anything in a hearing. A chairperson says, you know, now it's your turn to state your case and to also have your witnesses to come to testify on your behalf. Then the person just sits there like, I got nothing to say. You know, but they pleaded not guilty at the same time. Can you please talk to the employees about this, as I'm talking about the right to be heard?
You know, one thing about rights is, and in law, is every action is an action. If you decide not to talk, you know, to be heard, then whatever the employer is saying, their version will not be tested, will not be contested.
Please say that again. Every action?
Every action is an action. Every inaction is an action as well. So that's very important. So you sometimes when you say I'm not gonna be, you know, I'm not gonna say something, you're already saying something. Because in law, if you don't say something, the other side, its version will be regarded as the only version put before the commissioner. And another, it's very important for you to attend and address those charges. And that's why it's important when you have a charge sheet, if you have never been through a disciplinary hearing, it's important that you find people who you can coach you, train you, and prepare you for that. And another thing, Solomon, what I've seen is some people choose not to attend.
That's another thing.
Some people choose not to attend. And they're like, but I didn't do that. Your failure to attend does not mean that you're going to make the employer feel bad. And you're going to, it's like sometimes employees, they fail to attend and they want to put the employer in a way they're like, their hands are tied. So what are they going to do? And guess what? The hearing will proceed and that notice will tell you. If you don't attend, the hearing will proceed without you. So that right to be heard is very important. And it's important that if you then now, because I've had cases where I literally say, here we can't assist. You were given an opportunity by an employer to attend and address those hearings. Because when they put the charge sheet before you, they are not saying you are guilty.
No.
It's an inquiry. It's a disciplinary inquiry. They want to find out whether their investigations and the allegations that they have put to you, whether they are true, and you are given a version to correct that and to defend it. So if you don't attend, then the hearing will happen without you, and you will find most of the times it will not be in your favor because we never had the opportunity. And when you elect not to attend, it means that you've elected not to participate. So you are basically saying whatever they decide, that becomes the case.
Your inaction.
Yes, your inaction.
Your action.
Your inaction becomes your action. Yeah.
I love that.
Yeah.
So, when it comes to employees,
Yeah.
I issue the employee with the charges
Yeah.
to attend a disciplinary hearing
Yeah.
or suspension.
Yeah.
What should employees do immediately?
Yeah, I think once an employee has done that, has been issued out with a charge sheet, it's important to understand the charges, to understand what the suspension means and what you're supposed to do and not what to do, because you can transgress again during the suspension moratorium, So it's important to understand. Read it carefully. If you don't understand, find people who can actually, break it down, for you. In smaller granules that you can actually understand. So that's what it means. Okay, this is what I can do. This is what I can do. They're not saying this because sometimes they come to us, I've already been dismissed.
Yes.
Solomon has dismissed me.
Yeah.
But no, it's just saying we are doing an investigation. Yeah. So it's important for you to actually get some form of advice. And I think that's why HR is important as well. Because they play that pivotal role of actually making the employee understand. So you can, during that time, actually say, you know what, I'm not really understanding, and you can literally, ask them to just have a quick session with you just before they.
Love that, because one of the things that I love doing, before I can even proceed with a hearing, I like to understand if an employee understands the charges, because that's also one of the critical things. I've seen employees coming and say, I did not steal it, right? I'm being accused of stealing.
Yes.
But I did not do it. Yes, this was on me. I was about to take it to whatever, blah, blah.
Yeah.
You know the story.
I know the story, yeah.
Yeah. So what you're saying is key, that if you don't understand the charges, or even if you think you do understand the charges, to really consult.
I think it's very, very important. Because that's the beginning of actually preparation of the matter, to understand. Because you can't fight something that you don't understand. You have to understand. Because once you have that understanding, then you can literally, because sometimes you even, without that understanding, Solomon, you don't even know what type of evidence to gather, what type of witnesses to bring. So it's important to understand, what is the employer saying? What are they saying that I did? And then once you have that, you actually in a position now to say, no, but I have this document, I have this communication, I have this witness, I have the email. But sometimes if you are not prepared now, you go there and then the employer, because Solomon would have coached them and prepared them, they're just going to run over you and you are not ready. So it's important to then look for people who understand, who can be able to just assist you during that process.
Interesting.
Yeah.
One last, I think this will be my last long, because we've been talking, but it's interesting because, we do this every day and it's part of our lives.
Yeah.
What are those mistakes that employees, this time around, I want to understand from employees' perspective, that they do when they attend CCMA matters?
Okay.
Yeah.
I think, again, when they attend CCMA matters, they are trying to, I think one thing I've noticed is when you go to the CCMA, you are meeting someone who does not know you. That's what I always tell the clients. First of all, your demeanor, you need to be a credible witness. I think that's the most important thing in any courtroom. You have to be a credible witness. The person who is saying the story must believe you. So, for example, if you're asked a question, you must stick to the confinements of that question. You can't say, they've asked you, okay, we want to go, we're here, we want to go to Pretoria. What are the directions to go to Pretoria? You're just supposed to say, listen, we go into the freeway. Once we go into the freeway, we're N1, we pass through Midrand, we pass through Centurion, we are in Pretoria. It's a straight line. You don't say, you know what, you go into the freeway, then you go to Tembisa, and then you go to Katlekong, and then you do this, and you're all over the space. Your story your version must be consistent. It must be straight. But you see, people they think, because they don't know specialized people like you, that you're going to come for them in cross. So they forget the things that they have said.
Yes.
So your your version must be straight. Rather stick to one story. This is what happened, don't try and change, because once you change that version, you then put in the mind of the commissioner a little bit of doubt. And that window of doubt is going to be used against you. I think that's the most important thing. Your story must be straight. Number 2, be prepared. Have your evidence. Have your bundles ready. Know where everything is, right? If you have done something wrong, don't lie.
Yep.
If you did it, say, Commissioner, I did it.
Yep.
At least the commissioner can say, okay, you did it, but maybe let's look at the sanction. Maybe dismissal was a too harsh sanction. Because sometimes you have done it. The video evidence is showing. You went to the polygraph, you have failed. There are witnesses that are showing.
Yes.
Everything is just pointing towards you. And you still say, I did not do it. You see, and remember, at the CCMA, it's not a beyond a reasonable doubt. That's not the threshold.
Yes.
The threshold is not beyond a reasonable doubt. It's on a balance of probability. Can your version be believable, or the employer's version? So I think that's very important. And sometimes, be honest, sometimes we have to tell clients, listen, we cannot turn water into wine. You did it. It's wrong. There's no prospect of success. Let go and move on. At least build a good relationship with the employer for future references.
At any day.
And sometimes, the worst advice, last one, mistake sometimes employees do when they've done something wrong is not to heed to the advice of the commissioner and also the employer. And I can bet you, sometimes when you guys have those off-the-record meetings, you even tell the employee, listen, we can give you a reference letter. You even sometimes go on their side. You even plead with them.
All the time.
But sometimes people just don't want.
Yeah.
So I think just having that appreciation and taking responsibility when you've done something wrong, especially taking responsibility and being honest with yourself.
You know, Tatenda, that is a golden nugget. I'll always, any case that I do, if an employee say, you know what, I'm guilty, I accept it. I did it. Yes, it was a mistake. It was an oversight. And you know what? I'm here.
Yeah.
I'm at your mercy.
Yeah.
Please forgive me.
Yes.
I will not do it again.
Yes.
And normally when I have those kind of cases, the initiators, they calm down. They even sometimes mitigate on the behalf of an employee.
Yeah.
Seeing that this person really wants to repent.
Yes.
You know, I think that's a proper golden.
I think that's very important.
People don't talk about this.
You know, I've had cases where a husband and a wife would have come to the office and the charges are there. And, you know, the charges are serious. And I asked you, did you do it? And said, yes. He says, but I want you to prepare me. I said, I can't prepare you for something that you did. The best thing is for you to show remorse, because it's a big mitigating factor.
It's a huge one. It is considered. Anyway, even if you were to go to CCMA, before the commissioner, they look into that, because the intention of the employer taking disciplinary action, it's not always about dismissal.
Yes.
No. That's why they call it corrective action.
Corrective action.
Try to correct somebody.
Are you rehabilitable? Can you be rehabilitated into that environment? And most of the clients sometimes would call us, I can't believe that they've taken me back just by showing that you are remorseful. And sometimes, remember, you've been working for them for 19 years. you become part of the furniture. You're
Yeah.
part of the family.
Yeah.
So it's not like an employer who just want to say, I'm firing you with that long service record. Just show, and it's a leadership trait to say, listen, I'm willing to take responsibility. And then we've had others where they say, you know what, we have dismissed you, but you know what, we are willing to give you an independent contractor agreement, arrangement.
Tatenda, the thing is, people don't talk about this. People always talk about charges, firing. You know, this is the process of firing. But there is a human being behind an employee.
That's true.
You are a human being, then then you can become an employee.
Yeah.
And you know, all of us we make mistakes.
Yeah.
That's the honest truth. I'm speaking from the employer side.
Yeah.
I know that people make mistakes.
Yeah.
Every single day.
Yeah.
But if people don't own up to their mistakes, that's where the problem comes in. And that's where dismissal comes in. That's where the perception that you don't want to change, you will not change, right? Because one of the elements in Sidumo case,
yes,
it's exactly that. It's very clear whether you've given the employee the opportunity, to reflect on whatever that they did,
yeah,
whether they are remorseful.
yes,
Those are the things that we check for
precisely
when we make those decisions. So let's get into our rapid fire round.
yeah.
Settlement or arbitration?
Settlement. Settlement.
Settlement. Okay. Investigations or hearing?
That's a tricky one. Investigations or hearing?
Yeah,
Investigations.
I agree with you on that
Yeah.
one, personally.
Yeah.
Biggest HR mistake you've ever encountered?
I think the biggest is not understanding categories of law, of labor law. So we are currently dealing with a matter, just a quick one, where an employer dismissed someone saying that you are not performing, right? It was a performance issue, and then they dismissed this person for incapacity due to ill health.
No. Whew. I wish I met you before, because one of my nephews was dismissed for incapacity due to poor performance. However, he was found guilty. There was a verdict. There was a finding of guilt. How do you find somebody guilty for something that is not of their own doing? I mean, if you say
it's a no-fault dismissal.
No fault dismissal. So yes, okay. We're gonna. I know you and I will never finish.
Yeah.
Most misunderstood label or concept. What will that be?
For me, from an employee side, it's constructive dismissal. They don't understand that constructive dismissal doesn't mean, it is not an employer rebuking you or correcting you. That's not constructive dismissal. Because I feel like sometimes people don't like to be corrected.
I agree.
And yeah, so they just feel like if an employer is saying, you are late, you've done something wrong, it's not constructive dismissal, it's correction.
Then people resign. One word that defines a successful employer. You are also an employer.
Yeah.
What would be that one word that defines a successful employer in labor space?
Being human.
You gotta be a human being.
You have to be a human being.
What's that one word that defines a successful employee?
Humility.
If you could change that one thing about South African employment relation environment tomorrow, what would that be and why?
I think I would change the mindset of what it means to work. Yeah. When you are at work, your employer is, let me say this just to understand. if I were to change something, or if I were to want something to happen, you know, in the employment space, I would want the same character, attitude that one has when they are going for interviews on their first day to be the default attitude, you know, during their employment journey. Because in the first day, everyone is on their best behavior. And they are willing to listen to that person who's interviewing them, their prospective line manager.
Yep.
I feel like if you create that mindset, you won't have issues in the workplace. Just that, you know, that best behavior, and to know that you are at work. I think that for me, it's a mindset about work. You know, it's not an entitlement to go to work. It's a privilege.
Love that.
Yeah. So I think, because once you have entitlement, you start looking, you know, you start focusing on things that are not important. That's when it's easy now to look at the wrongs. Oh, there are no biscuits. There's no coffee. There's nothing. But that's when you started in the interview, you didn't care whether there was coffee or biscuits.
No.
You were willing to say, man, people were, most probably by the time you came, the parking lot had your prayers. You were praying and you wanted to get that opportunity. But I don't know why. Sometimes we get that opportunity and then we act like that opportunity is now a curse.
It's horrible. It's bad, you know. It's like you see a lot of stuff that we deal with on a daily basis, you know. But anyways, so for people that are currently looking for opportunities to get represented, or people that are going through a disciplinary hearing right now, with their employers suspended, how do they get hold of you?
I think you can look for us on www.employmentlawveritas.co.za. But we are big on socials. TikTok, you can look for Labor Law Veritas. Instagram, our handle is Labor Law Veritas. If you just look there, you will definitely find us as well. Yeah. So we are willing, or you can call us on 011-531-8995. Yeah, so you can just reach out to us.
Look, you have a very expensive address. I'm sure people are wondering. Somebody might be sitting and thinking, "Ooh, those guys! I don't think I can afford those people." You know, but they need help.
Yeah.
How do they? Is there a way that you guys are able to assist?
Yeah, we do. We definitely assist. I think because we understand that most people who are in that space, who have been they're not working. So we do have an arrangement, you know, consulting fee arrangement where we will assist you, you know, for free, and then we will then, if we win, we then, you know, take a certain percentage consulting fee arrangement of some sort, that we have. So at least, you know, we have, it's upon us to win so that we get paid as well. So definitely it will be in our best interest to make sure that we get a reasonable outcome for you. And definitely, depending on how much you earn, your dynamics, we also have a billable rate that is very, the price point is good, you know, for people who are not working. And we can always formulate payment arrangements in that front,
I love that. So you heard it for yourself, guys. If you have a matter currently and you need assistance, Labor Law Veritas is available to assist you. I, for one, am very excited to learn of this, opportunity.
Yeah.
You know, for you guys that are listening, you know, watching. One last thing that you'd wanna say but before even that, you know, South Africa is going through turmoil at this moment with regards to the 30th of June, undocumented foreigners,
sorry,
things like that. For employees that are currently working, who are scared for their lives, who are probably being dismissed because of their nationality, what would you say to those people right now?
Yeah, I think it's just a call to say, to encourage everyone. You know, I think each and every country has, you know, they always have their own problems. But I think if you are documented and I think my advice is definitely to, if you are concerned and if you, depending on the environment that you're staying, I think by law you should have, because human resources is a very key component. Talk to your HR. If you have to work from home for some time, just to allow the tempers to cool, down. I think that's the advice that I would give you. You need support, counseling, mental counseling, because people are really going through a lot. And I think it's just important that you as a person to protect your life, your family in the best way you can. South Africa is going in a very precarious position. The unemployment rate is high. So sometimes it's people who are protesting from a point of pain. I don't think it's you have to take it personally, but protect your livelihood and protect your life. And I think it's just more jobs to a lot of entrepreneurs, that if we can get support to be able to create employment, because I think once employment has been created, no one is going home hungry and thinking someone is taking their opportunity. I think it's just creating more employment, and then to the rest, to the people who are working. When you see people protesting outside there and they are saying they don't have jobs, I think it should give you a perspective that you must take care of your jobs, because there are people who actually want to be in the position that you are in. So it just shows you that if you are working, you're at a point of privilege. But if you are not working as well, I don't think complaining is something that you should always, I don't think it's going to solve much of it will definitely give government attention and definitely work on it. But I always tell people, if you don't have a job, you can always start from being a volunteer. Find something that you can do. That's how it always works. If you don't have something, find a place that you can be a blessing and start working from there. And you'll be surprised the skill set that you'd have, the experiences and the conversations and the relationships that you have. I believe if you apply yourself in whatever space or country that you find yourself, you can find a job if you're not working. But put yourself in the space that you want and go for free. Because anyway, you are staying at home. What are you doing? You're not getting paid. So rather find something that you can do. And then along the way, someone can just say, hey, what are you doing? Or there's a temporary position. The next thing, boom, you are in there. And the next thing, opportunities. That's how they flow. When success is when preparation meets opportunity. Yeah.
One of my friends used to say, Vumile Melani, used to say, preparation prevents poor performance.
Definitely, it does.
If you don't go out there, look for opportunities, they will not come looking for you. My brother, I'm a bit emotional because, a lot of people are working for their families.
Yeah.
And yes, I'm all very sympathetic with everybody that's looking for jobs, who are unemployed. But I'm completely against people who are saying foreign nationals are taking jobs. I don't think that. I think this is a big issue. It's a very dynamic issue that requires, serious intervention from various departments and organizations.
Yeah.
And us also as a nation, and also as a continent. Yeah. Because this is a continental matter.
It's a continental matter.
I'm not a politician.
Yeah.
I don't want to talk politics. But at the end of the day, tomorrow, if 30 people leave company X and they have certain skills, tomorrow if they are absent because of these issues that we are currently facing, it might certainly mean that other people within those organizations, they will lose those job opportunities. I'm talking from a perspective of an employer. But also as employers, we must be responsible, hire responsibly, follow the laws, so that our companies can also be protected. Otherwise, thank you very much, and I really appreciate the opportunity to speak with the director of Veritas, of Employment Law Veritas. One of the companies that you find on social media. He mentioned that you can check them on TikTok. You can check them on where? Facebook?
Yeah, Facebook,
LinkedIn?
LinkedIn, we're there as well.
All
yeah,
right.
on
No.
all the socials. Yeah,
Thank you very much for coming.
yeah.
And I hope to meet you in the CCMA one day.
Thank you so much. Thank you
All
so
right, no,
much.
thanks.